points just to cover. This session is being filmed. It's been streamed live on our Twitter account and on YouTube. What that means is that, one, people can watch it live, but it also means if you want to see anything again from this session, or if you have to leave halfway through, go onto our YouTube or onto our Twitter page. You can find a recording of it alongside the slides that Colette's going to be using today. So that's there, or if you're struggling to hear at the back. So my name's Ben Fisher. I'm Head of External Communications here at the SRA. But the star of the show today is Colette Best, who's our Policy Manager. Previous to working at the SRA, her experience was in sort of financial services and housing policy. But since she's joined the SRA, she's been our lead on our anti-money laundering work. And I think I'm right in saying she's been involved in that work for over a decade, because she previously worked on the implementation of the money laundering regulations at the Royal Institute of Chartered Surveyors. So without further ado, I'm going to hand over to Colette to talk you through money laundering.
Anti-money laundering, actually. Oh. Okay, now that we're back at the beginning of slides. So firstly, thank you very much for coming to what is, I think, the graveyard slot to come and hear about anti-money laundering. I know everyone's quite keen to get home and learn about what's happening in Brexit, so we'll try and keep this fairly interactive. So firstly, I think it's a good idea to remind ourselves of what money laundering is and why it matters to us at the SRA. So money laundering is basically using the profits of the worst crimes in society. So if you think about the types of crimes that are going to generate large amounts of profits, it's going to be things like drugs dealing, illegal arms trafficking, human trafficking, and child pornography. So it's really about stopping those crimes from being profitable. The definition also includes terrorist financing, even if that money is from a legitimate source. So just to put that into context, if I were to use my SRA salary to finance ISIS, that is automatically terrorist funding, even though the source of the funds is clean. Whereas money laundering is if I am involved with a drug deal and profit from that, it's not yet money laundering. But when I seek to introduce the profits of that deal into the financial system, that's the point at which it becomes money laundering. So I was in a meeting with the Home Office yesterday. They've just launched a new serious organised crime strategy, and some of the statistics on kind of drug use, arms dealing are really quite horrifying. And what they're saying actually is that most drug dealers now consider a prison sentence very much as a cost of doing business. Going to jail is basically not a deterrent to this crime. But what is a deterrent is the fact that they might not be able to introduce their profits into the financial services system. So you guys really are at the forefront of stopping drugs dealing, terrorist financing, human trafficking, and all sorts of kind of nasty crimes that we want to avoid. So I guess if I can leave you with one thing today, it's that anti-money laundering isn't just a lot of acronyms, although we do love an acronym in this world. It's actually a bit more important than that. It's about stopping terrorism and really awful crimes. So that's one very important reason about why we care. But another really important reason for us at the Solicitors Regulation Authority is that we obviously have a strong interest in protecting the integrity of the legal services market in the UK. And I think this is going to be getting even more important sort of in a post-Brexit world where we're potentially competing on a global stage for the legal services market. So we've seen other industries begin to be tarnished with money laundering scandals. We've seen quite a lot of high-profile prosecution of banks, for example. And we've had a few kind of near misses in the legal services sector. So you'll remember the Panama Papers, more recently the Paradise Papers, and that's the sort of thing that we're very much seeking to avoid. And I think money laundering is one of those areas where the vast majority of people do absolutely want to do the right thing. but a small minority can very much tarnish the reputation of the majority. And more recently, we've seen quite a lot of law firms named in a Private Eye article in connection with dodgy Russian money. So that's something that we are monitoring and we are writing out to firms on. A couple of other really important reasons why we care. So we ourselves have a new oversight supervisor called OPBAS, which is the Office of Professional Body AML Supervision. OPBAS have been put in place by government to supervise all of the professional bodies that have anti-money laundering responsibilities. So there's 22 of us spread throughout the UK in the legal and accountancy sectors. And OPBAS have a handbook which basically dictates the way that we have to regulate money laundering. So it is a bit more of a prescriptive approach than we've been used to in this area. We also get regular compliance visits ourselves from OPBAS to check that we're doing a good job of this. So we are under very close scrutiny in this area. There is also quite a lot of international scrutiny. So around this time last year, the UK had a visit. It's a kind of a once-in-a-decade visit from the Financial Action Task Force, FATF. And FATF is the international body that sets money laundering standards across the globe and then goes around the country, that goes around the world assessing those standards. So quite a lot of international scrutiny. The report was published in December of last year, and I'm pleased to say that the UK got, in fact, the highest score of any country in this round of visits. So we're kind of doing quite a good job internationally. But the report did make quite a few recommendations, and we do expect those to start filtering down to us. So potential changes coming in there. Okay, so I think, as I said earlier, when thinking about preventing money laundering, it's important to think about what exactly you're trying to prevent. It's not a box-ticking exercise. It's about stopping money laundering. It's stopping drugs trafficking, terrorist financing. And the policies and procedures that I'll speak about are really important because they're set out in legislation, but they're also really important for keeping you safe and your firm safe as well. So one of the things that we do is we survey firms on attitudes to risk. And firms say that actually they think money laundering is a really big risk. It's really important. It's a vital area for the sector, but it's important for kind of the guy down the road, not necessarily for their firm. So I guess the message is that this is really important for everyone to make sure that we're doing well. So where is the risk of money laundering? Where does the risk lie? It's really important that you guys at the forefront of preventing money laundering know where your biggest risks come from. So there's lots of information available to help you do this. The government back in 2017 published an assessment of the risk of money laundering and terrorist financing to the UK. And that was a joint Home Office and Treasury publication. And they flagged that the risk of money laundering to the legal services profession, and in fact solicitors in particular, is very high. They flagged that the risk of terrorist financing is medium. So it's well worth acquainting yourself with that document. We at the SRA also publish a lot of documents on risk, and one of the most important ones is our risk outlook. And that's an annual publication, but gets refreshed twice a year. And that focuses on kind of emerging areas of risks that we're seeing. And money laundering and preventing money laundering always features very highly in it. The other really important publication is that for the first time last year, we published our own sectoral risk assessment. And this is where we've set out in a number of different categories where we think the risk is to you guys as firms. So that's available online. I'd highly recommend you downloading it and having a read through it. But essentially it breaks the risks down into the categories that you see on the screen. So Just to expand on each of those, so product and service risk, probably not going to be any surprises here. I've already mentioned that the government thinks that the risk of money laundering to solicitors is very high, and that is primarily because of offering a conveyancing service and also areas of work such as trust and company service provision. The other area of risk that we think is quite high is operating a client account. We know that criminals are actively trying to target solicitors' client accounts, and that's because if you can pay money in and out of a client account, it is essentially laundered at that point. It is the kind of the purest form of money laundering. So risks from your clients, again, probably not too many surprises here. So political exposed persons are a high risk, and this is actually reflected in the 2017 regulations when they came in, actually expanded the definition of politically exposed persons. So previously, politically exposed persons had only been overseas people. The 2017 regulations expanded that regime to UK nationals as well. So you now need to worry about UK PEPs as well, also their families and close known associates. Customers paying in cash, it's quite an obvious one. And customers seeking anonymity or who are evasive about trying to prove their identity is a big risk factor. And then transactional risk. So again, probably not too many surprises here. So large transactions. And actually what a large transaction is probably going to vary for each of you. It's really for you to consider for your own firm what is a large transaction in the context of the products and services you offer. Electronic currencies is another one that we're quite worried about at the moment. So any cryptocurrencies that can facilitate anonymity are a risk factor for money laundering. And we think that the 5th Money Laundering Directive, once that comes into force, will bring cryptocurrencies into the scope of regulations. So that risk might be reduced a little bit at the moment, at that point. But at the moment, cryptocurrencies are a bit of a wild west and something to be aware of the risk of. And then unusual transactions that don't fit either your client profile or your firm profile is something to be very strongly aware of. And any transactions facilitating anonymity, so any way that perhaps assets are being held that disguises who's holding them is a big risk factor. So in terms of your delivery channels, as many of you know, non-face-to-face transactions are a big risk factor if you're not actually seeing your client face-to-face. Payments to or from a third party is another big risk factor, which is why if you do have funds coming from a third party, it's really important that you make sure that you identify that third party as well. And also combining services can raise your risk level as well. So for example, you might have a conveyancing traction that kind of on the face of it doesn't look that high risk, but if the assets are then being held in a trust that you're creating, the combination of those products and the delivery of them might begin to increase your risk level. And then finally, geographical risk, I think, is probably quite self-explanatory. So some of the things to be aware of is countries on the sanctions list or with a high number of people on the sanctions list, countries with high level of corruption, and countries with non-equivalent anti-money laundering standards. And if you download the sectoral risk assessment that I spoke about a moment ago, there are links to useful resources there on where these countries actually are. Okay, now that I've found my notes again. So those are sort of the more static risks. It's important to be aware that these risks are changing all the time. So firms are very much, money launderers are very much seeing one avenue for laundering money close down, and we're seeing problems springing up elsewhere. So it's really important to make sure that you're aware of kind of the emerging risks as well as the more classic ways of laundering money. So these are some of the things that we've seen our MLRO, Money Laundering Reporting Officer, has reported over the course of the last year. So fraudulent property and investment schemes is quite a big one at the moment, and we think that's primarily because of a number of people who have liquidated their pension portfolio as part of the pension reforms, and they're now being targeted by people seeking to get them to enter into fraudulent investment schemes. Funds and clients from high-risk jurisdictions. You might think that it doesn't happen, but we do have a number of live cases from clients coming in from high-risk jurisdictions, Iraq, Iran. It is very much a live issue. Funds paid into the client account from unknown third parties. This happens more often than you would think. A firm gets a payment into the client account. They've got no idea where it is, what it's related to, where it came from, and then get a call saying, oh, sorry, I've paid some money into your account. Please, can I have it back? At which point, if the firm does, that money is effectively laundered. No underlying service or purpose for transaction. We see quite a bit of that. And if you are using your client account without an underlying legal transaction, that is an incredibly high risk of money laundering, as well as being a breach of our handbook. False and misleading information included in client files, either because the client has provided false information and it hasn't been checked, or to gain the client's risk rating. And then facilitating fraud and tax evasion, as we know, are ongoing problems. So as I say, it's worth bearing in mind that these are live cases that we've seen over the last year or so. So it's just worth bearing in mind how you would deal with these situations if they happen to you. So that's where the risk lies. So if you're in scope for the money laundering regulations, what exactly do you have to do to mitigate that risk? So the first thing I'd say is that there's a whole industry surrounding AML compliance, and you can spend masses of money on consultants' fees if you so chose. But actually a lot of this is quite straightforward and quite intuitive, so there's no reason that it isn't something that you could do in-house. So the Money Laundering Regulations 2017 are the primary regulations that set out your obligations. And they basically set out what you have to do to prevent your firm being used to launder money. So the first thing is to know your risk. So I've just spoken quite a lot about where we see the risks sitting to law firms. And the sectoral risk assessment that we've published should be able to help you with this. But essentially you must make sure that you have a firm's risk assessment written down and regularly refreshed. And actually I'll speak a bit more about this in a moment. And then once you've identified where your risk lies, you need to decide what you're going to do about that. So you need to have policies, procedures and controls that are written down and kept regularly refreshed, which set out how you're going to manage your risk, what your risk tolerance levels are, how you're going to undertake client due diligence, how your records are kept, and you also need to monitor your compliance. And these policies and procedures should also set out what happens if you come across a client or transaction that is above your risk threshold. And then you need to make sure that you've trained your staff, both in the relevant legislation, so that's money laundering regulations and proceeds of crime regulations. You also need to train your staff in your internal policies, procedures and controls. So you can have the best controls and procedures in the world, but unless people know about them, they're a bit pointless really. So people need to know where they are and what they say. You must know your customer, their source of funds and their source of wealth. So quite a big chunk of the money laundering regulations set out the different criteria for identifying different types of clients. So it's well worth having a read through the standards that are required for different client types, so that you know how to identify a company or a trust or an individual. But essentially you need to get information that will allow you to identify the customer and actually what the intended business relationship is. And if there's a beneficial owner, so for example, if you're involved with a conveyancing transaction and the deposit's being gifted by a third party, perhaps someone's parents, then you need to make sure that you identify that beneficial owner, that third party as well. And then once you've established the identity of your customer, you need to do what's referred to as monitoring the business relationship. So that's making sure that the services that customer is taking up are in line with what you would reasonably expect and what they originally set out when you established the nature of the business relationship. You need to make sure that the source of funds that they're using is in line with what you would expect, and that's also an ongoing process. And then you need to report suspicious activity. So this is a really important one. So you need to have a money laundering reporting officer in your firm, and staff need to know who that is. And they need to know how to go to that person if they've come across something suspicious. So they need to know how to submit an internal suspicious activity report. And the money laundering reporting officer needs to know how and when to make a suspicious activity report to the National Crime Agency if they do have a suspicion that money laundering is taking place. And then you need to keep records of all of the above for 5 years at least. So, are we nearly there yet? How are firms getting on? So I think we've come a long way, but we're not quite there yet. We get quite a lot of information feeds about compliance with the money laundering regulations and Proceeds of Crime Act. And I think a lot of the information that we're getting in at the moment suggests that there is quite high levels of non-compliance with the money laundering regulations. One of the things that's particularly concerning us at the moment is that the National Crime Agency publish their statistics annually. And the most recent report suggested that the number of suspicious activity reports from solicitors went down 10% last year. That's on top of a 12% decline the year before. And this is at the same time when reports from other sectors, so for example the accountants, are actually going up. So it is a bit of a concern that the levels of suspicious activity reporting is beginning to decline. So as I mentioned before, we do get quite a lot of intelligence feeds about how firms are complying with the money laundering regulations, and we do quite a lot of work ourselves to check on compliance. So we do surveys, we do thematic reviews, we have regular feeds from the National Crime Agency, which at the moment are report kind of pointing to concern in a couple of areas. Very recently we did a thematic review on money laundering compliance by trust and company service providers. The findings of that will be published hopefully next month. But in essence we went to visit 60 firms to check how they were getting on complying with the money laundering regulations. And of those 60 firms, we've actually referred 26 of them into our enforcement processes. So quite a high level of non-compliance, quite a bit higher than probably what we were expecting 2 years after the new regulations came into force. And the areas that firms seem to be struggling with are around the firm's risk assessment, which we know is a new requirement in the 2017 regulations, but it does feel as though firms still haven't quite gotten to grips with it. And also firms struggling with certain aspects of client due diligence, in particular the PEPs, politically exposed persons regime, and not having policies and procedures around dealing with PEPs. So, as I say, those are the main concerns. And as I've mentioned earlier, we also have quite serious concerns about the numbers of suspicious activity reports being submitted. That we found that a number of firms that we visited hadn't submitted many reports, either internally to their MLRO or to the National Crime Agency. So I've spoken quite a lot about the firm's risk assessment, and I just wanted to expand a little so that you can see what exactly we're looking for. And just to put this into context, we are about to do a major monitoring exercise to call in firms' risk assessments. So over the next couple of days, we'll be sending out 400 letters requesting firms to submit their risk assessments to us. And we'll see how that goes, and we'll probably be doing another enforcement exercise towards the autumn. So this is very much a live issue for us, and something that we could potentially be calling in firms' risk assessments. So if that does happen to your firm, what exactly are we looking for? So I think that the main thing is that this document forms the basis of your armour against being used for money laundering, and it helps you set out what your risk threshold is. So one of the most common questions we get to our ethics helpline is, I've got this client come through, these are my concerns, I don't know whether to take them on as a client or not. In that situation, your first point of call is your firm's risk assessment, because that sets out what your risk tolerance is, so that everyone is clear on whether this is a type of client that falls within your risk parameters or not. And basically, we're just looking for something that demonstrates you've thought through where your risk lies, and you've taken kind of a considered approach to the different requirements in the regulations. And as I've mentioned before, the next stage in the process is to think about how you're going to mitigate this risk that you've identified. So you need to be thinking about who your clients are, what is unusual for you and your firm and your clients, what's unusual, what does an unusual transaction look like in the context of your firm, and in the context of the services that you're offering. And as I mentioned, a really good starting point is the firm's sectoral risk assessment that we published last February, available online, and it does take you through all the different risk factors that you might want to set out. So what's the SRA's focus going to be for the next year or so? So this remains kind of a top priority for us. We think that preventing money laundering is one of the biggest, if not the biggest issue for solicitors, the legal profession, and in fact the country as a whole. So it remains a very high priority for us. I've mentioned our concerns about compliance, so these are two areas that we are going to be focusing on in the next year. So firms' risk assessments and the number of suspicious activity reports submitted. We will be calling in a number of firms' risk assessments, as we mentioned, and we will be looking at the numbers of suspicious activity reports and, in fact, the quality of reports submitted to the National Crime Agency. And our intention is that we're going to be publishing the findings of our thematic review very shortly. We're also considering publishing a warning notice setting out exactly what the concerns are on compliance, to let firms know exactly where we're seeing non-compliance. We're continuing intensive monitoring in this area, so I've spoken a bit about that. We'll also be doing another thematic review this year. And the current thinking is that this will focus on high value or cash conveyancing transactions, because we see that as a very high level risk. And we're also prioritising the investigation of anti-money laundering type cases. So we're just in the process of setting up a dedicated team to look solely at AML cases, so we can handle those in kind of a timely and a consistent way. So, as I said a bit earlier on, this is an area that is quite fast-moving. So criminals are constantly seeking new ways to launder money. And that means that government, both UK, EU, and the Financial Action Task Force to kind of continually seeking legislative solutions to prevent money laundering. The first thing that's going to hit us is going to be the implementation of the 5th Money Laundering Directive. That has to be implemented by, it will probably be coming in either December of this year or January of 2020. We don't know too much yet about how Treasury will choose to transpose that. We're expecting a policy consultation coming out imminently, and then a further regs consultation from Treasury in the autumn. But we think that the directive will put kind of greater importance on transparency of ownership. And we're beginning to hear about initiatives such as beneficial ownership registers, company registers of beneficial owners. It will also probably bring new sectors into the regulations. So I spoke about cryptocurrencies earlier. We think those will come into scope of the regulations for the first time. Similarly, letting agents we think will come into scope of the regulations. And it will also require greater separation of representation and regulation in both legal services and accountancy supervisors. I also mentioned kind of towards the start that we've been recently reviewed by the Financial Action Task Force, and although we did get a very good response from them, an excellent report, there were a number of recommendations, particularly around the legal and accountancy sectors. So we could well see changes coming in from Treasury off the back of that report. And we do continue to be monitored by the Financial Action Task Force to make sure that we are implementing their recommendations. So this is going to be an ongoing process with them over the next couple of years. And we also know that the government is placing increased importance on the financial sanctions regime. I think this is going to be particularly important again in a post-Brexit world as we seek to demonstrate that the UK is kind of a clean and transparent centre for doing business. So lots more importance placed on the financial sanctions regime. We know that the government has also set up a new National Economic Crime Centre, NEC, which will help coordinate all of the different government agencies in preventing economic crime. And try and put in place sort of a public-private partnership and preventing money laundering for the first time. And then the other thing to bear in mind is, so I've spoken a lot about suspicious activity reports, the kind of the low levels, and I do acknowledge that the current online reporting system for suspicious activity reports is pretty hard going. It's quite antiquated. We know that the National Crime Agency is in the middle of a transformation programme to try and put in place a new IT system for submitting suspicious activity reports. Alongside that, the Law Commission closed a consultation late last year on the whole suspicious activity reporting regime and kind of the complexities of it, because it is an incredibly complex and difficult regime, particularly where it intersects with legal professional privilege. So we're hoping that they will report soon, and there might be some simplifications of both the reporting regime and actually the mechanism for submitting suspicious activity reports, because I do acknowledge that neither of them are particularly easy to navigate. And we're obviously feeding into that process, but it's well worth you keeping an eye on. So we do publish quite a lot of information to help firms comply with the money laundering regulations. I've spoken about quite a few of them, but our risk outlook, the national risk assessment and the sectoral risk assessment are all available online to help you with identifying risk. We have warning notices setting out where our concerns lie, and we also published our findings of our thematic reviews, which set out examples of good and poor practice, so those make great reading if you've got a moment. We also link on our website to the Legal Sector Affinity Group guidance. So this is a single piece of anti-money laundering guidance that's produced for the entire legal services sector in the UK. That guidance is approved by Treasury, which means that it does provide you with legal safe harbour if you are following that guidance. So it's a very helpful piece of guidance to be aware of. And we also have our professional ethics helpline and web chat. So we have advisors on the end of the phone who are very happy to pick up any queries on specific money laundering issues that you might have come across. And that's where to go for all the information that we publish. So how are we doing on time? So we've got about 10 minutes or so for any questions. We don't have roving mics, so if anyone's got any questions, I might ask you to stand up and shout, if that's okay. But any questions about the money laundering regulations, our compliance regime, the levels of risk? No? I can tell you're all keen to get home and start watching the Brexit votes. Okay, well, as I say, there's lots of information online and lots of avenues for asking questions. I'll be around for a few minutes afterwards if you're kind of feeling a bit shy about asking in front of the group and want to come and have a chat. And do by all means ping me an email if there's anything that you want to follow up on. And thanks very much for coming. Thank you.